AI.
So, Mr. Chair, the provision in question, which is not related to the amendment that I believe is before the committee, but the provision sets out the types of high-impact AI systems that will be subject to regulation. And the schedule does list a number of high-impact AI systems, including those that can influence behavior as it relates to online recommendations. And that type of artificial intelligence system is the subject of considerable amounts of activity in the international fora.
I have Mr. Turnbull on a point of order.
Relevance is the point of order, which is a point of order. This has nothing to do with the amendment that we're focused on, which is the change of a number, is the adding of a 1 to the schedule for ease of reading. So what I'm not understanding here is how Mr. Perkins keeps asking questions about something that you've already indicated is 20 pages in to the amendments we have that has to do with ADA, the ADA portion of the bill. That's not the portion of the bill that we're focusing on. This is the very first amendment, and this looks very much like a filibuster.
Thank you, Mr. Turnbull, and I accept your point of order. I'll ask members to stay relevant to. On clause 2, we still have, if we get through this amendment, we still have 155 other amendments to go through. So that's just on clause 2. So we need to move a little more swiftly. And so I'll ask members in their questions and their comments to stay relevant to the amendment that's before the committee. Do I have any other? I have Mr. Mass. You still have the floor, Mr. Perkins, but please stay relevant to G1.
In the last Parliament, the government tried to legislate algorithms through C10 and then backed off and then brought in C11 this time and said, look at us, aren't we being nice? We're just going to tell people how to write their algorithms, not actually look at them. But in this bill, Schedule 2, which is numbered Schedule 2, and you're having to amend Schedule 1 as Schedule 1. Because of Schedule 2, I'd like to know...
Sorry, Mr. Perkins, I have a point of order.
Mr. Perkins keeps referring to Schedule 2, which is not this amendment. The amendment specifically refers to a 1. So maybe he could refrain from referring to a schedule that we're not debating.
Well, it's an administrative... drafting convention that the government has introduced because they had made a mistake in the drafting of this bill and introduced a Schedule 2 in the draft that was given to the committee in advance as a draft amendment the minister's 8 after his appearance, and then now as formally through the clause-by-clause process introduced it. It's very clear to most people that the drafting convention is you can't have a Schedule 2 if there is no Schedule 1. It just doesn't make sense. And therefore, the government drew the link by introducing this that allows us to be relevant in the discussion, because I don't believe you can have the other amendment without this amendment.
Well, that's a good question to ask the officials, Mr. Perkins. Perhaps I would ask you to stay on the formatting or the numbering of the schedules, not the substance of the schedules. We'll get to that if we ever get to that, Mr. Perkins.
Can you introduce Schedule 2 as Schedule 2 if you don't renumber the annex schedule as Schedule 1?
As noted, Mr. Chair, I think the likelihood is if this does not get numbered as a schedule, it would have implications then for the subsequent schedule, and there would probably be a move to try and keep the two consistent. And so this one would refer to an unnumbered schedule, and so then would the schedule reference in AIDA.
So that's the relevance. That it has implications on Schedule 2, which allows us in this instance today to ask about that schedule and make sure we understand what the impact of not having that change in Schedule 1 done and its implications in 2 if 2 isn't in this bill the way it is. So we get, I believe, to ask questions because the Assistant Deputy Minister has just made, once again, the link between the two.
If I understand correctly, Mr. Shan, what you're saying is that basically it would be named differently provided this change in G1 is not adopted, but the substance of them would not change. It's how they are labeled. So I would appreciate questions on the labeling of the scheduling, not the substance of the labeling. We will get there, Mr. Perkins. Trust. Well, I'm not so sure we'll get there, but I hope we'll get there. It's in the plan. So, Mr. Perkins.
I'll go to the next, whoever's next on the list.
Thank you. I have Mr. Massey.
Just real quickly, normally we have the department come that's actually proposing legislative changes in front of us, and I think this is the problem that we're faced here, is we have the Department of Industry here representing the Department of Justice. Has the Department of Justice provided any written material that you can give us at committee so we can actually resolve this? My standing convention is that a department really actually has representation in front of the committee when it wants amendments. That's the problem here, is we have basically a vessel for justice coming for an amendment at industry here, and there's the confusion because regardless of such, there is consequentiality of this change. Otherwise, they wouldn't be asking for this change if there wasn't a reason and there wasn't consequentiality. And if it was convention that it be included, then that's a pretty bold mistake to begin with in the legislation. Or alternatively, it has a consequentiality that we know. So is there any written information for the Department of Justice? Can we get anybody on the Department of Justice on the phone for this? I don't know. It's just, yeah, call a friend. Well, it's a mess because we have a vessel here. Well, we're here for a reason. No, I mean, the parliamentary secretary can shake his head and they can heckle and they can do all the stuff they've been doing this beginning of this meeting, but it doesn't take away from the fact that there's a lack of trust here and we don't have, again, information. So specifically, is there any written information from the Department of Justice or a representative of the Department of Justice about the amendment they want for this industry legislation?
Specifically for G1, you're asking, Mr.
For
Massey.
G1, yes.
Mr. Shan.
I have no written information from the Department of Justice. I have, as we will throughout the entirety of this process, be relaying information that is both of a content nature as well as of a drafting nature. I will be relaying that as it has been relayed, and in this particular case, it is about the drafting convention of the naming of schedules, and it is simply such that it is understood that schedules are best understood with precision, and therefore we are asking for it to be renumbered.
So the bottom line is I couldn't be bothered to show up. That's the bottom line. That's the bottom line. And I guess the other question I have is, what other department amendments do we have other than industry that are going to come forward in the number of amendments that we have coming forward? And maybe we should have them here with us, available. I mean, if we want to get this done properly.
Thank you, Mr. Massey and Mr. Viss.
Thank you, Mr. Chair. Regarding Schedule 1, it refers to subsection 6.3. What page can you point me to in the legislation for subsection 6.3?
Mr. Chair, on page 7, under application,
Thank you.
3, this act also applies to an organization set out in column 1 of the schedule in respect of personal information set out in column 2.
This act also applies to an organization set out in column 1 of the schedule in respect to personal information set out in column 2. What organization is that? Is that the one that Ms. Angus referred to, Mr. Chair? The World Anti-Doping Agency?
That's correct.
Okay. And then paragraph 122.2. Let's look at that as well. What page is that on, Mr. Chair?
That would be on page 61 of the bill, under orders. 2C, amend the schedule by adding or deleting in column 1 a reference to an organization, or by adding or deleting in column 2 the description of personal information in relation to an organization in column 1.
That's 122C, specifying information for the purposes of Section 51. Am I reading that correctly?
That's correct.
No. Okay.
122, 2C.
120. Oh, my apologies. Amend the schedule by adding or deleting in column 1 a reference to an organization. Where is column 1?
Column 1 is in the schedule.
Okay. Which is the only column, column 1 being the World Anti-Doping Agency.
There are 2 columns. Column 1 is the organization. Column 2 is a description.
Okay, so it's amend the schedule by adding or deleting in column 1 a reference to an organization, or by adding or deleting in column 2 the description of personal information in relationship to organization 1. So what is the impact of 122C then on the schedule outlined?
The purpose of Section 122 is under the regulations, the general provisions of the Act. It sets out the requirements by which the Governor and Council may make regulations for carrying out the purposes of the Act.
Sorry, I have bad hearing.
Apologies, I can say that again. Section 122 specifies as how the Governor and Council may make regulations for carrying out the purposes of the Act. And so the recitals following that cover off what the conditions are that must be met and how you go about doing that. And the second section, 122.2, notes that the Governor and Council may, by order, and the point of C, which is the specific article you referenced, is that the Governor and Council may amend the schedule where currently the World Anti-Doping Agency is referenced.
Yeah.
That the Governor and Council could add other organizations, or adding or deleting organizations from that list.
Okay. My second question, so we received, I don't know the exact date anymore, but in respect to the naming convention, when we received the high impact systems schedule, Schedule 2, was the Department of, just out of curiosity now, because we've had such a fascinating discussion about it, was the Department of Justice, did the Department of Justice write?
Point of order.
Mr. Turnbull.
So the member keeps referring to Schedule 2. I think we've over and over again have gone back to referring to Schedule 1. The amendment that we're actually discussing and debating right now is only a 1 added to Schedule to clarify. So Mr. Viss, I don't know where he's going with this, but it's not relevant.
Specific and on topic, Mr. Chair, and I continue to be. Yes, I have, because the department sent forward a number of amendments after the bill was tabled, one of them being Schedule 2. So did the officials from the Department of Justice did they have in mind this first amendment when Schedule 2 was provided to this Parliament after the bill was tabled?
Not aware of exactly the line of thinking that went into the particular determinations, but there is a determination from the Department of Justice that the bill would be improved by naming Schedule 1, and then Schedule 2 would follow as a function of AIDA.
Through you, Mr. Chair, did the Department of Justice write Schedule 2, or did the Department of Industry?
Mr. Chair, the production of government amendments goes through a drafting process by which the Department of Justice and the Department of Industry collaborate to create the amendments that are before the committee today.
Mr. Chair, it is of a significance, and despite the badgering from the Liberal members, the high impact system, Schedule 2, is legislation that everyone understands is going to have a big impact on Canadian society. So I'm just trying to understand what the rationale or thinking of the officials was when they gave us an amendment to a bill that was tabled before clause by clause outlining a new schedule without giving us any context as to other changes that would be forthcoming.
I know we're all eager to get to the end of this clause by clause and to discuss the substance of Schedule 2, Mr. Viss, but now we're really...
I'm not interested in the
we're looking at the
substance of Schedule 2.
labeling, which is to add a 1, that's Government Amendment G1, that's what's before this committee. So if there are there any other comments on G1? We can disagree or agree with the labeling.
Yeah.
The substance we will debate, and the amendments you're referring to we will debate.
Yeah.
But now we're on G1, or the very first of a big stack of amendments. And it's a very simple one. I'm looking around the room. I see Mr. Williams.
I'm done. Thank you.
First, Mr. Chair, I will do the relevance of this subject. I just want to make a quick comment, though. I think that there have been some comments from the other side of the room on the fact that we're trying to filibuster or we don't have the right to question. You know, this bill is very important. It's very important to Canadians. It's very important. I know people in this room. Of course, we'll get into privacy as a fundamental right. Of course, we'll get into some other substance of this. But it does start from the first recommendation from a government. This is a government recommendation. And we want to, of course, we have concerns with where this points to. Certain aspects of this bill, it's going to, of course, bring big debate to this. And I think part of that is understanding why the decisions were made and why we're going to be making further decisions down the road. So this is relevant in a lot of ways to ask the relevant questions as to why we have a number 1. And my question to the officials, to you, Mr. Chair, besides the Schedule 2 that I seem to see in amendments, are there other schedules that are going to be introduced to this bill in any section, in any part of the law?
To my knowledge, there's a schedule proposed for CPPA and there's a schedule proposed for AIDA.
So you did answer. You said no, but you answered yes. So there's more than one schedule. So we're labeling this number 1, but there's one for AIDA. Is that what you're saying?
I believe we've already understood, Mr. Chair, that there is a proposed amendment that would introduce the schedule to AIDA. So those are the 2 schedules that are currently before the committee.
Thanks. Sorry, I think you misunderstood me. I just asked if there was more than the one here before us. So of this amendment, there is a change to number 1 in this schedule, but to your knowledge, there is another amendment coming to add a section 2. Is that correct?
No, Mr. Chair, there is one schedule to the CPPA, and this amendment seeks to label it as such, as Schedule 1. There is a schedule that is proposed in later amendments to the Artificial Intelligence and Data Act, and that is the amendment proposes to call that Schedule 2.
Okay, so to clarify, yes, there is a schedule for this one. There's going to be a schedule for AIDA. That's proposed as the amendments. I think that others have been referring to. So are there any other, I'll ask this one directly, are there any other schedules proposed or talked about to any of the rest of this document?
Mr. Chair, not to my knowledge, there's no amendments that further introduce schedules.
Okay. And when we look at Schedule 1, you've already answered to my colleague that we have the World Anti-Doping Agency. This pertains to that. Of course, we can debate the substance of that later. But in terms of being able to add anything else, would there be any other number conflict? The Department of Justice, have they had any other concerns about labeling or numbering for any other part of this document? Was this the only change that they said needed to be labeled for protocol or decorum?
Mr. Chair, there are other technical amendments that are introduced as we go through that relate to specific drafting wording. I don't believe they relate to numbering, but not to my knowledge. But there are other technical amendments that are proposed.
Okay, just I guess a general question. At the end of this study, we normally come back and look at the title. We'll look at, I think, the preamble. If there could be other schedules added to the course of debate of this, why are we doing this at the beginning, not at the end?
Mr. Chair, as I understand it, the annotated agenda for the consideration of the bill was to take it in course, and so this is the way in which the committee has decided to adjudicate the bill.
Okay, well, I think in that context and spirit, I think what I'm going to recommend is we table this motion, Mr. Chair.
Mr. Williams, I'm afraid that's not going to be possible unless we completely adjourn the meeting, because if we were to do that, we would, and correct me if I'm wrong, Jean-François, but we would have to set aside Clause 2 entirely. And that's 156 amendments, and G1 is the first of these 156 amendments. So, so the other way is we can vote on G1. I would humbly suggest.
Yeah, well, anyway, I think we're seeing the problem here, and I think let's point this out. The government brought this C-27 through in June 2022. We waited a year; it was tabled before it was introduced. We had a bunch of amendments brought to this bill. Now we're debating the First Amendment, where we're not sure if we have a Section 2 or 3. Even if that's going to be there, and we're starting with that. I find that very problematic. It follows how this bill has been rolled out and introduced and debated as a whole. So I think we have major issues sometimes with how we're bringing this through. I hope this is a learning experience for most people, but at this time, this was a bad way to bring a motion forward towards this committee. Thank you, Mr. Chair.
Okay. Merci, Monsieur Williams. Est-ce qu'il y a d'autres?
Thank you, Mr. Williams. Any other comments?
On the government amendment G1, shall G1 carry? Now I see there is no agreement, so we'll go to a vote, Madam Chair, on G1.
Mr. Turnbull?
Yes.
Ms. O'Connell? Yes. Madame Lapointe?
Oui.
Mr. Sorbera?
Yes, please.
Mr. Van Bynen?
Yes.
Monsieur Généreux?
No.
Mr. Perkins?
No.
Mr. Viss?
No.
Mr. Williams?
No.
Monsieur Garon?
Oui.
Mr. Massey?
No.
So, colleagues, it is carried. Congratulations, first of 156 on Clause 2. Moving on. And the next one I have on my list is CPC 1. So, who do I recognize? Mr. Viss.
Well, thank you to all my committee members, and today I am very pleased to speak about CPC 1. Over the course of all of our meetings, I really emphasized a lot the need for a fundamental right to privacy, like many of you did as well, and the special rights that we have the opportunity to put in place to protect not only our freedoms, to ensure fairness, and to push for a just society, but do so specifically for Canadian minors. Let me break it down for you. CPC 1 essentially embeds the preamble into Part 1 of the Act and adds a crucial clause. It will now read, whereas the protection of the fundamental right to privacy of individuals with respect to their personal information is essential to individual autonomy and dignity and to the full enjoyment of fundamental rights and freedoms in Canada, whereas the processing of personal data should respect minors' privacy and their best interests. So why do these changes matter? The Office of the Privacy Commissioner has noted that as C-27 is currently drafted, the preamble of Bill C-27 only appears in the introductory text of the bill and not at the beginning of the CPPA or ADA. According to the Privacy Commissioner, once enacted, neither act will contain any mention of the preamble, which includes the bill's only mention of the fundamental right to privacy. While, yes, I understand that the preamble of an act is not legally binding, it does provide guidance to the courts with regard to the intention of our work in drafting this bill. When privacy interests and those of businesses are in conflict, the inclusion of the preamble will allow the courts to identify the intent of our work here at committee. In addition to embedding the preamble into the Act, this amendment also makes changes to the preamble's existing text. One, it strengthens the recognition of a person's fundamental right to privacy in the existing text to make a specific reference to the right to privacy. And two, it recognizes that the processing of personal information of minors should respect their best interest. These amendments were recommended by the Office of the Privacy Commissioner as a means to strengthen privacy protection for all Canadians. More specifically, the Office of the Privacy Commissioner, in the submission made on April 26, 2023, has made it clear that the preamble of the bill they stated that privacy is both a fundamental right in itself and is instrumental to the exercise of other rights. Also in this submission, the OPC makes recommendations and proposes amendments in the following 5 areas to advance this broader theme: privacy is a fundamental right, children's privacy and the rights of the child, appropriate purposes, and administrative monetary penalties and disposal. They recommended that the preamble should recognize that the processing of personal data should respect children's privacy in the best interest of the child. The preamble of the bill would apply to CPPA and ADA, which is why the OPC believes it is important that this amendment is included in the text of the bill. Their submission also stated, as the preamble would apply to all the acts compromised in Bill C-27, including the CPPA and ADA, adding the proposed language to the section that frames the legislation's intent would help ensure that the best interest of children and minors are prioritized and consistently considered across all the related acts. At our meeting number 87 on September 28th, the Privacy Commissioner repeated what was voiced in the OPC submission. He said, under the theme of privacy as a fundamental right, I recommend strengthening the preamble and purpose clause to explicitly recognize privacy as a fundamental right and highlight the need to protect children's privacy and the best interests of the child so that these important principles inform the interpretation of all aspects of the legislation. In addition to listening to the recommendations given by the Office of the Privacy Commissioner, it is very important for us to listen to what other stakeholders said on this as well. In meeting number 99 on November 28th, Elizabeth Denham, who is the Chief Strategy Officer of the Information Accountability Foundation, came to voice her input. She's worked for decades as a privacy professional and worked for 15 years as an information rights regulator in 15 jurisdictions. She previously had a role as the Information Commissioner for the United Kingdom in 2016, where she brought into oversight the board that administered the General Data Protection Regulation, an important part of the EU privacy and human rights law that was also raised consistently at our meetings. While working as the UK Information Commissioner, she oversaw the creation of a children's appropriate design code in which the design of that code has influenced their laws related to privacy. The GDPR's Children's Code of Age-Appropriate Design assists organizations in creating digital services that cater to children's needs, respects their rights, and fosters their exploration and growth online. In later meetings, I will speak about this further as we have an amendment that would create a similar code to protect children in Canada. With that being said, I think it's important for us to recognize what the GDPR has done in explicitly emphasizing the language of the best interests of the child. Furthermore, in meeting number 99, Ms. Denham emphasized the importance of including privacy as a fundamental right and the best interests of the child in the preamble. So that's two of the leading experts globally who happen to both be Canadians are asking for this. She said, looking first at Canada's CPPA from a global perspective, I see a big missing piece. And the legislation's language, in my view, needs adjusting so that it explicitly declares privacy as a fundamental right for Canadians. Its absence really puts us behind nations who lead the way in privacy and data protection. She also stated that one of them needs to be a statement in the preamble or in the purpose statement that recognizes that companies need to provide services in the best interest of the child. That language comes out of the UN convention that I mentioned earlier. Canada is a signatory to that, the best interest of the child, end quote. During meeting 98 on November 23rd, we had Michael Bouvet, a doctoral candidate at the University's Toronto Faculty of Law. He said that the best interest of the child should be included as a fundamental principle in the Act. Doing so would make the child's interest a primary concern in all aspects of the proposed legislation. For example, the best interests of children should matter in specifying the purposes of data collection, use and disclosure, as well as data retention, end quote. Again, during meeting 92, on October 26, Associate Professor of Law at the University of Colorado Law School, Vivek Krishnamurthy said, including language, and I quote, that says that the best interests of the child needs to be taken into consideration throughout the interpretation of the subsequent provisions, means that if you're doing a legitimate interest analysis, that's going to impact that analysis by the company or other organization that's collecting and processing children's data. During meeting 94 on November 2nd, Interim Director of the Privacy, Technology and Surveillance Program of the Canadian Civil Liberties Association, Daniel Konikoff, alluded to the fact that the current legislation does not give people a fundamental right to privacy. He said, first, Bill C-27 does not give fundamental rights. They're due and frequently puts them in second place behind commercial interests. It has been said before, but CCLA believes that it's worth emphasizing that Bill C-27 must be amended to recognize privacy as a human right, both in the CPPA and ADA, since privacy is something that should be respected at all points throughout the data's life cycle, end quote. The stakeholders and witnesses have been diligent in making their case on why we must include this critical amendment. As legislators that serve a democracy, it is crucial for us to draft legislation that listens to the voices of professionals in this field, and they have been very clear on this point. I now want to further emphasize the importance of why this bill needs to specify a fundamental right to privacy and a child's best interest in the preamble. Firstly, privacy has long been considered a fundamental right in Canada. Our Charter of Rights and Freedoms, along with the Federal Privacy Act, territorial and provincial privacy legislation, work together to protect Canadians with respect to their personal information held by government or private institutions. Recent trends and events have raised new concerns about whether personal information is adequately protected by governments and companies when this information travels outside of Canada's borders. With the increasing flow of computerized data across international borders, particularly to the United States, privacy concerns and the rights of Canadians to safeguard their personal information makes it more important than ever for the language of a fundamental right to be included in the preamble of the bill. Canada has signed the Universal Declaration of Human Rights in 1948, which is an integral part of protecting individual autonomy, dignity, and fundamental rights of all people. We need to ensure that the text of this bill emphasizes that this right, as Article 12 of the Universal Declaration of Human Rights states that, and I quote, "No one shall be subjected to arbitrary interference with this privacy, family, home, and correspondence, nor to attack his honor and reputation. Everyone has the right to protection of the law against such interference or of attacks," end quote. Privacy is a fundamental right because it is intricately tied to our dignity and the enjoyment of other fundamental freedoms. Let me elaborate on this. Privacy is not merely about keeping secrets. It's about control over our personal information. Our identities, beliefs, and choices are deeply connected to the data we share. We heard that time and time again throughout all of our meetings. Respecting privacy rights ensures that individuals maintain their dignity and autonomy. We think about some of the conversations we had during the meetings about what this will do to protect young people that might make a really bad decision when they're young and online. We need to make sure that this law gets it right so that children have a right to have those bad decisions forgotten online, so something's not following them throughout their entire careers and personal life. Essentially, it allows us to define who we are without undue interference, either intentionally or unintentionally. In cases of conflict between private interests, such as convenience, business, or security, as outlined in the bill, and public interest, privacy should always prevail. This balance acknowledges that while innovation and security are essential, they must not come at the expense of individual privacy rights. Privacy isn't an obstacle to progress. It is the catalyst that all of us have spoken so clearly on through this whole process. When people trust that their data is protected, they are more likely to engage in positive digital activities or even use new technologies in a way that might help our economy, for example. Canada's innovation and competitiveness therefore rely on this amendment to provide a robust framework that encourages responsible data use. Privacy will accelerate trust. When citizens feel their privacy is respected, they trust their institutions more. As digital citizens, we want to participate fully in society and the economy without compromising our fundamental privacy rights. In summary, privacy as a fundamental right is crucial for our digital age, which is why the preamble of the bill must highlight this right. It ensures that we can benefit from technological advances while safeguarding our personal information and giving the tools to the courts to make future decisions. Secondly, I want to emphasize the importance in including the second half of the amendment, which states that the processing of personal data should respect minors' privacy and their best interests. This line is vital at the beginning of the bill as it sets a precedent and standard that should be followed throughout. This is especially important as the bill proposes multiple clauses that are subject to a lot of regulation by the Department of Industry. By specifically indicating the precious needs of minors' data and taking a nuanced approach which puts children first, we are putting protections that will hold future regulators and commissioners accountable to this fundamental concern that we have all outlined during our meetings. More specifically, the concept of best interest of the child is, in fact, an international standard. It was first established in 1989, serving as the primary United Nations Human Rights Treaty, which focused on safeguarding children's rights. In Article 3, it states, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of this child should be a primary consideration. This declaration underscores the universal recognition of the importance of prioritizing children's well-being and interests in all decision-making processes. Particularly, number one, the best interest of the child will be a primary consideration in all actions affecting children. That there will be no discriminations on the grounds of race, color, sex, language, religion, political or other opinions, national, ethnic, or social origin, property, disability, birth, or other status. And three, states or parties that have signed this recognize that every child has the inherent right to life and will ensure the maximum extent possible to survival and development of the child. And four, children will be assured the right to express their views freely in all matters affecting them, their views being given due weight in accordance with the child's age and level of maturity of age. Incorporating the best interests of the child into this legislative framework is not merely a legal obligation, but a moral imperative for all of us. It reflects our commitment to nurturing environments where children can thrive, free from exploitation and harm where possible, particularly in the digital realm that we discussed at length. The digital landscape presents so many unique challenges and risks for our kids. We can get this done. With this robust safeguard, we can protect our kids. Therefore, embedding provisions that explicitly protect minors' privacy and prioritize their best interests within the legislative framework is essential. Thank you so much.
Thank you very much, Mr. Viss, for moving CPC 1. I have Mr.
What a joke.
You said that was just moving it.
No, please, colleagues, please. I have Mr. Perkins that I recognize, and then Mr. Turnbull.
Order, Mr. Chair.
Mr. Masick.
I point out that this has not been the case of this committee. There's been 3 interventions from this member that are quite questionable in terms of parliamentary respect, and I would hope that would end. That's something significant for this committee because we can't have our differences, and I fought my differences with my colleague here at the beginning of this committee. in an open and accountable way that's actually recorded, versus this type of stuff that's taking place off the microphone is clearly unacceptable.
Thank you,
Mr. Chair?
Yes, Ms. O'Connell.
Mr. Chair, I apologize. I was laughing with my colleague, Mr. Turnbull, and Mr. Viss did not hear correctly what we were talking about, so if that has caused any disruption, I apologize. But to make some sort of statement that is incorrect is just not right. And Mr. Massey, his comments are fine, but I am allowed to talk to my colleagues at this committee.
I can quote back what you said earlier, that we're off the record if you like. If we do, good reading, mansplaining, other things that you've stated across the aisle directly to the member there.
Colleagues, usually at this committee we work very collegially and in respect, and I've heard from all sides throughout this meeting comments I don't wish to hear again. So please, if you have anything to say, you seek my attention, I'll give you the floor, and you say it on the record. Otherwise, we let other members speak and we listen respectfully. Thank you very much. Mr. Perkins.
Thank you, Mr. Chair. To the witnesses, in the last Parliament, there was a previous version of this bill which did not recognize privacy as a fundamental right, and there was a lot of kickback, I think, then. I was not in the last Parliament. But, and then the bill got introduced in June 2022, again, as we know, with not a lot of consultation beforehand. Is there a reason why legally the department's chosen not to put a fundamental right in the preamble of this legislation, since there have been 2 attempts at it and it still hasn't done that?
Mr. Chair, I appreciate the question. I think the views of the minister have stated, I think, the openness to seeing a fundamental right to privacy in the bill. And I think the views of the minister are, I think, reflected in both amendments, and I can't speak for the government. I can only speak from the department's perspective that we've reflected the wish to have fundamental right to privacy understood in this bill.
And I appreciate that, but the 55 government amendments, there wasn't one proposed in this area. So the Privacy Commissioner, in the Privacy Commissioner's submission in 2022 to this legislation, on page 8 says, as the preamble would apply to all acts comprised in Bill C-27, including the CPPA and ADA, adding the proposed language to the section that frames the legislation's intent would help ensure that the best interests of the children and minors are prioritized and consistently and considered across all aspects of the Act. So if the bill is amended in the preamble in this manner, does it affect all aspects of the legislation, including ADA? Sorry, so the Privacy Commissioner seems to be asserting here that if you amend the preamble in this manner, that it impacts all aspects. There's basically 3 pieces to this bill, that the preamble affects all 3 aspects, but in particular the first and the third. Would that be correct?
Mr. Chair, as I understand it, what is being proposed is that a preamble is being inserted into the CPPA. I believe there is also potential for a preamble to be inserted into the Artificial Intelligence and Data Act. So this preamble, as I understand it, would inform the reading of the CPPA. Right. When we come to AIDA, as I understand it, there are proposals on the table for a preamble to AIDA, which would inform AIDA. And so to the member's question as to whether this informs all 3 parts of the Act, by putting it in the CPPA, you are informing the CPPA.
Just the CPPA part,
correct,
not the artificial intelligence part. Okay. So the reason to do that, presumably, is because does the preamble as it's constituted now without this amendment, would the preamble actually be included in the final Privacy Act once published if passed by Parliament, or would it not?
In its current format, no.
No, it wouldn't. So then from the perspective of the department, what's the purpose of the preamble if once the bill's passed, it has absolutely no purpose or inclusion in the actual Privacy Act?
Mr. Chair, courts have often looked to the context in which the overall piece of legislation was introduced and understood. And so while not being party to the bill in its further carriage as a statute, the preamble offers interpretive value to the courts as to the thinking of Parliament and informs the consideration of its ongoing implementation.
So the impact of this would be putting this into the Act would only affect CPPA, and would that add more certainty, or would it cause a problem with anything else in the CPPA if you put it in? Because there's a reason why the government doesn't have it in.
So it certainly carries with the bill, so it becomes a part of the piece of legislation, which means that the legislation reads with it basically on an ongoing basis. I think inserting the preamble into the bill itself is a very direct mechanism by which to inform its ongoing interpretation, as opposed to a potential for a court to look back on the interpretive record. So to answer your question, it is a more direct way of ensuring that it continues to be understood in that manner.
Would the government have any objection to that?
I can't speak for the government. I can simply suggest that I think the preamble as an interpretive tool can be important. And I think one thing that we do think about from a technical perspective is that it stays consistent with the overall bill. And so it should ideally speak only to the CPPA portions of the Act, so as to ensure that the preamble is informing the Act in which it's included in, as in it shouldn't speak to other acts or other bills, because that can cause confusion. And so you might hear some thoughts on that.
So would it appear to be, if this goes in, but say Section 5, the purpose section doesn't change, does that provide clarification or contradiction?
I see no conflict between the purpose and this preamble. No.
And why in the preamble, and maybe you can't answer this, was the call out? One of the things in this amendment is the focus on a very specific issue around personal data with regard to minors and their best interests. MP Viss spoke eloquently to that issue. Why was that not seen to be a priority? Because in the minister's opening speech in second reading in the House and in my conversations with him, he said the primary purpose of this whole bill was really about protecting children's rights. But it seemed like when we go through it that there's actually very little reference at all. There's just a reference to minors once in the definition section. So why was it that the government, if it felt that what this bill was doing was protecting children's rights to a greater extent than the existing law, why wasn't that more robustly put in either the bill, in the preamble, in the purpose section, and various other parts of the bill?
So I think it's important to understand, Mr. Chair, that the escalation of the personal information of minors to the class of sensitive information is an extraordinarily powerful legislative tool. It essentially insists that all parties subject to the CPPA will be held accountable to the degree to which they put in place appropriate safeguards in their privacy program for minors' information on the basis that it is in fact by just its existence sensitive. And so I think that is a fundamental way in which we've addressed the issue of minors and their information by assuring that the level of care and conduct that's afforded to it is quite elevated and significant.
In the existing bill, but is what you're saying that are you trying to say that we don't need this to do that?
So I think we're talking about two different things, Mr. Chair. I think we're talking about a preamble that provides interpretive value to the overall bill and highlights in the Conservative amendment the important issues related to minors' privacy. But the bill itself has provisions in terms of fundamental obligations on those actors who are subject to the law to treat minors' information as sensitive, and so they're not in conflict. But they're different things.
Can you point me specifically to the clauses, because I can't find any reference to minors other than the definition section.
So G5 and G55 both speak to the fundamental right of privacy.
In the existing bill, I mean.
And in the existing bill, the elevation of children's personal information to the level of sensitive is found. Section 62.
Page.
2 seconds.
What page is that? Sorry, what page is that?
I'll just give me 2 seconds.
30, page 30. 62.2, sub E.
Doesn't say children, it says sensitive personal information.
I don't see any reference to minors or children,
It's a reference to sensitive information,
regardless of age. So it's not specifically
but
called out for
including
minors.
minors.
To be treated in an even different way. It's treated the same as adults.
Sensitive information of sensitive information of all adults and all informations about minors. So it's not going to be treated exactly the same way as adults, because only sensitive information of adults will be treated as sensitive. And for children, minors, it's all of their information is considered sensitive and treated in that way.
This motion.
No, not if the amendment passes. I'm talking about the existing bill. So in the existing bill, where does it state that minors is treated differently?
Where?
Give me a second, just. It is page 6.
Definitions.
At the very top of page 6, interpretation minors.
For the purposes of this act, the personal information of minors is considered to be sensitive information.
Right.
The provision that Ms. Angus just read out is how sensitive information is treated in the act.
Okay, so not being a lawyer, help me out here, because that is the only reference I found in the Act to minors, and it uses the exact same language as it does for adults, which is that it's sensitive information.
No. So I think the important clarification is that there is information of adults, a subset of information related to adults can be considered sensitive, and what this does is includes all information related to minors as sensitive.
All information as opposed to some.
Correct.
Okay. Yeah. Thank you for
No worries.
clarifying that. I guess Mr. Chair is not here. Mr. Vice Chair is.
Usually.
Clarification, Mr. Chair, about NDP 1 and conservative 1.
Yes, Mr. Massey.
I believe NDP 1 is no longer relevant if conservative 1 passes, if I'm correct.
I'm not sure that's true.
No, this is not the information I have.
Okay.
But
Because
I
it has
think-
additional things.
I have a couple of,
Yeah.
yeah.
So,
I just
and
wasn't sure about.
NDP 1 would still be receivable.
Okay.
Should
Great.
CPC 1
Wasn't sure, just wanted to.
carried. However, I think we
You
might
guys on the list? Ryan?
have some more. I think Mr. Turnbull might have something to propose on
Sure.
this.
Yeah,
And I will recognize Mr. Turnbull.
fair enough. Thank you, Chair. Okay, so great to talk about this. I think first thing I'll start with, I think, is that there's some support for this in principle. There's both aspects of the NDP 1 amendment, which is put forward, which also expresses some language to go in the preamble, which is now being inserted into the CPPA, that we support in principle. There are still some challenges perhaps with the wording, but I want to express support for the fundamental right to privacy and the protection of minors. I think there's a little bit of course, that's something that we support, but I think there's some language. What we've done is taken away both of those and considered perhaps a kind of a compromise of language that we could propose. Obviously subject to the committee's debate and vote, but I wanted to maybe just start with a couple of clarifications. So I know Mr. Massey had brought up a point that I was going to clarify too, that CPC1 is a standalone amendment, and I'm looking to the legislative clerk perhaps to just clarify. My understanding is that NDP 1 and CPC 1 are separate, can be voted on separately, and they do not impact one another. Is that correct?
Oui.
Okay. Okay, and then the other thing I wanted to, and similar to Mr. Perkins' line of questioning, but I might take a slightly different angle, Mr. Shan, perhaps you could clarify whether the coexistence of a preamble in the bill and the preamble in the CPPA could cause conflicts in terms of interpretation, and whether there's any specific concerns that you could raise for us that might come into effect if CPC 1, as stated here or as proposed, were to pass.
Thank you, Mr. Chair, for the question. I think to build on an earlier point I was making is that because this is being inserted into the CPPA as to inform the interpretation of the CPPA, our one area of concern is that it does actually then reference content related to the Artificial Intelligence and Data Act, particularly that it speaks to a particular aspect of technology above others that we think potentially may cause interpretive challenges. So in the CPC 1 amendment, it states, whereas Parliament recognizes that artificial intelligence systems and other emerging technologies should uphold Canadian norms and values in line with the principles of international human rights law, I think our thought is that that clause may actually suggest that the preamble is straying into territory to inform artificial intelligence regulation as opposed to privacy regulation.
So I know the Conservatives are trying to tell me something here, but I believe it's the reference in what is being proposed that includes reference specifically to artificial intelligence systems, that embedding that into the language of the preamble of CPPA makes it less technology agnostic in terms of language. Is that what you're saying, Mr. Shan?
Yes, as a principles-based statute and a technology-neutral statute, the CPPA aims to inform privacy practices for all corporate activities, and so by including specific reference to artificial intelligence systems in the CPPA, we think there might cause interpretive challenge.
Thank you. With regard to minors, going back to something that was clarified earlier, and I know the Conservatives were bringing up the definition of sensitive information, or classifying all personal information of minors as sensitive. Perhaps we can clarify the approach that we've taken in the bill in terms of the drafting of it with regards to minors, because I know that that's something I feel very committed to. I have a young daughter. I'm very concerned at her information being shared online. Very want to make sure that children are protected, and I think a part of this inserts the concept of best interests of the child. And I think there are ways that we've dealt with that throughout the bill, and or have proposed amendments on that I want to make sure that don't get confused in terms of what I might propose here in terms of a language around a sub-amendment to this particular wording. So I just want to clarify protection of minors. Mr. Shan, can you maybe outline our approach to that? And specifically, I'm looking for, information on how we're specifically making that a priority in this bill.
Absolutely. So, through the amendments that are being offered, as well as by the bill text itself, as I noted, the most fundamental shift is by declaring that minors' information is sensitive and needs to be treated as such, and that's an elevated bar for the purposes of a privacy management program, and would engender a very significant level of scrutiny on the part of the privacy commissioner as to ensuring that the safeguards in place were there. We in a number of spaces speak to, through the amendments, the notion of ensuring that minors have the capacity to have their information thought of as sensitive, have their parent or guardian potentially act on their behalf in doing so, but also to have a capacity understanding that would be in place so as if a minor has capacity to do so, they would be able to act on their own behalf. And so this potentially as a necessity to be implemented by folks. The best interest of the child is obviously very good declaration language. In terms of precise obligations as it relates to it, I think we've suggested that it's important to get at the construct of being able to act on behalf of a minor, and then also to have the capacity of the minor understood in cases where that capacity would be able to act on their own.
So if I'm to clarify the approach, it's not that the government position that we don't disagree with wanting to protect the best interests of the child, and that's exactly what we want to do. So the intention there is pure, and I think the right one to have. But the mechanism with which to do so within the language of the bill, it seems to me that there may be some challenges, with embedding the best interest as wording in the preamble of the bill, which may cause some challenges later on, because of course we have to debate the substance of the bill later, and if we decide one way or another whether to go with best interest or the capability test, which I think is what we've proposed or what we intend to propose at that point, because it hasn't happened yet. But can you just outline for me why there's challenges around best interest in terms of embedding it in the language of the bill? And I'm not just talking about the preamble, because I'm taking it, that there's an implication here. If we embed it in the preamble and then later on that term is not used in the bill itself, I think that creates interpretive problems.
I think where possible, we seek to have the consistency of language both in the obligation and in the ambition. And the preamble obviously sets the ambition of the bill, and then the obligations of the bill will follow. I think, as per your previous point, I think there is an intention on the part of the government through their amendments to very much get at the issue of minors' rights to privacy. But the best interests of the child as a legal obligation, when we get to the obligation section, is a subjective construct that potentially introduces quite a bit of ambiguity to the part of the commercial actor who needs to make the determination on that, and may actually engender quite a bit more collection of personal information to be able to understand and interpret what is the best interest of the child.
Well, and I guess to some degree, and Mr. Viss said this in his opening remarks introducing this, putting children first and maintaining their dignity and autonomy, which is language that I largely agree with, which I think is part of why perhaps we want to also ensure that those who have the capability of making that determination over how they exercise their rights over their personal information, which will come up later, that I think is the intention behind some of the language that we intend to include or would like to see included in the bill. Is that right, Mr. Shen?
That is correct, yes.
Okay, so I guess the other thing is like who determines the best interest of the child. I think is the challenge with the interpretation of the bill, with dealing with the commercial entity. Does that commercial entity, is it able to determine the best interest of the child, or is it dependent upon the parent to do so? And I think, can you clarify how the language in the bill makes it or includes parental authority in the actual bill?
So in the amendments that and in the text of the bill, the construct that the government has put in place is both to treat children's information or minors' information as sensitive, authorize parents and guardians to be able to act on behalf of those interests, but then also to include the prospect that where the capacity of the minor is understood to have sufficient capacity, that they would be able to make determinations in their own right. And so introducing a new construct